It's Thursday, it's September 4th, it's trial day 9. Today's the day for closing arguments. You know what we don't know? When they'll finish their closing arguments, how long the jury may be out. From the prosecution, I'm pretty sure they're going to remind the jury of some of the testimony they heard early on in trial. And they're going to highlight the things that I think the defense found the most challenging. The jailhouse informants, the evidence of flight, and the "I know I'm next" text, I suspect. We're going to see the defense saying there's no evidence that she intended to kill Dan Markel. There's no evidence that she helped plan the first-degree murder. And I think we'll see the defense really focusing on first-degree murder. We heard them at the charging conference talk about the jury instructions yesterday, and so they were going over all of the different jury instructions for the 3 charges and any lesser includeds. Murder in the first degree, conspiracy to commit murder in the first degree, solicitation, so somebody else will commit that murder in the first degree. We're going to go to court this morning, see what they put on the record. The court has allowed each side 2 hours. Jury instructions, prosecutor, defense, prosecutor, rebuttal. It's time for closing. Let's just go to court. I'm ready. You're ready. We're ready.
Your Honor, given the court's ruling on that, we would ask that second degree and manslaughter not be given.
On what?
What?
Your Honor.
On the basis that it's bad?
Charging document briefly.
The defense asked yesterday for the lesser included. The defense is now saying, I don't want the lesser included of second degree and manslaughter, after the court said, well, intent's not required for those crimes. Like, that is known. That's not a surprise.
As I indicated previously, Your Honor, it's our position that the 2 sentences at the end of the principal instruction, specifically for second degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. As I indicated, it's a question of intent, and the principal instruction.
The difference between first degree and second degree is intent, counsel. Oh my God, what are we arguing about? This is not new.
Main portion, defendant intended the crime to occur. I just think it's confusing. I understand the state's position, but under the circumstances, we would request that the court not give those 2 lessers.
What?
Moment.
As I'm understanding, they're requesting just for count 1 simply to be guilty of first degree murder or not guilty?
No. Mr. Evans to omit the lines pertaining to second degree murder and manslaughter in the 3.5 sub A instruction.
No, I don't think that's what they're asking.
Mr. Evans' understanding of our request is accurate. We're asking that the 2 lessers for count 1 not be given, and that would eliminate the necessity for those 2 sentences in the principal instruction.
What is the state's position?
They agreed to the lesser included and asked for one yesterday. So the defense is like, we don't want the lesser included. We agreed to the lesser included yesterday. They wrote the verdict form yesterday. They went over all the jury instructions for the lesser included yesterday, and now he's like, oh no, I don't want those lesser included.
We're fine with doing away with the lessers.
What?
On this matter, I will need to take a call from the defendant.
So the prosecution's like, cool, fine, lessers, no lessers, whatever. And now they're going to ask the defendant. They asked for the manslaughter lesser. They asked to not have the second lesser. The prosecution then asked for the second lesser. And because the lessers are to be given unless both sides don't want them, they asked for the manslaughter one. The prosecution didn't ask for any of the lessers, I think, until the defense asked for the manslaughter one. It doesn't matter now. They're asking for them to be taken out. So there we go. Okay. And they're going to swear in the defendant and ask her about it.
Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can lower your hand. Ms. Adelson, you understand that lesser included crimes are something that is available depending on what is charged as a crime.
I understand that.
Do you also understand as well, if you waive your ability for the jury to make this finding, they can only make a finding as to what is charged first degree murder?
Yes, that's correct, Your Honor.
Yeah, we know
Consulting
it's
with your
correct.
attorneys, you understand the strategy of waiving all lesser included crimes.
I do, Your Honor.
Is there anything that you need to consult with them further
Okay.
about concerning this matter?
No, there is, Your Honor.
Then you may be seated. As to the jury instructions, I will remove second-degree murder and manslaughter as options.
And the last issue, Your Honor, we had discussions yesterday concerning a corrections officer at the Leon County Detention Center. We were able to get her served. An investigator was able to track her down.
What?
Ms. Kessler, my paralegal, spoke with her afterwards. The information that she provided is our position that anything Officer Franklin would have to offer is not admissible, and that is why we did not seek to call her prior to arresting.
There's a little bit of defense CYA. Cover your ass. That is 100% the lawyers saying, Your Honor, this is the subtext. Our client wanted us to call this witness. I am making a record that we found this witness, we served this witness, we spoke to this witness. This witness has no admissible testimony, which is why we didn't call this witness. That is the defense attorney making a record if there is an appeal. Because somewhere down the road, appellate counsel is going to look at this case if Donna is convicted. Given that Charlie was convicted, given the evidence in this case, the defense has to look at that as a very, very real possibility. And they are covering for when appellate counsel looks at this case and says, those defense attorneys didn't call that one witness. They didn't push for more. Note it for the record, Your Honor. Your rights are preserved. Law nerds, we are gathered here today for closing arguments. Let's talk about what happened this morning. They did a lot of work on the record before they officially
bring the jury.
The court denied the defense motions with regard to Donna's planners. I mean, I'm just curious, if I was a juror, I would want to read through them all too. They're not evidence. They're not in evidence. Some of them, or the 2014, didn't even have foundation except for one page. Not evidence, not coming in. The defense addressed the instruction regarding who is a principal of a crime. And with regard to who is a principal of the crime, that was discussed amongst the lawyers. That instruction informs count 1 and count 3. But it was amended to include the proper instruction as to the lesser includeds. At the end of that discussion, the defense said, well, can we remove the lesser includeds then? And I was like, what are we doing? And then the prosecution's like, yeah, sure. And I'm like, well, all right then. So the lesser includeds that they all discussed yesterday and added to the verdict form yesterday have all been removed. And the case goes forward to closing argument and to the jury as charged. Count 1, 2, 3, no lesser includeds, which means the prosecution probably had to go pull a few things out of their PowerPoint and they had to make sure they don't address it and explain it. With that, they are going to go on the record. The judge is going to read the jury instructions. When we get to those jury instructions, I will highlight the instructions of the crime. Those are going to be the elements that the court tells the jury that they need to find. Let's get to closing argument.
This is Dan Markel. He's the victim in this case. A son, a brother, a colleague, a mentor, a professor, a friend, but most of all, a father, an Abba, a dad, a dedicated and loving father whose downfall was brought about by the fact that his number one priority was maximizing his time with those little boys in the wake of a bitter divorce from their mother. Defense called witnesses to come in here and give you an expert opinion that his divorce and the subsequent litigation was not contentious. Not contentious to whom? It was contentious to Dan Markel. It was contentious to Wendy Adelson. And it was contentious to this defendant. And then after telling you what a great guy Dan Markel was in opening statements, they called witnesses to tell you what a pain in the butt he was. And he was a pain in the butt to those people, those awful lawyers that can't even admit that divorces are emotionally charged. He was a pain in their butts. He was a pain in Wendy's butt, and he was a pain in Donna's butt. Why? Because this was his life we were talking about. Dan Markel was not a file on some lawyer's desk. He was a real person who cared passionately about every scrap of paper in that divorce file. He wasn't some bumbling idiot. He was a Harvard-educated law professor. And yeah, he was making it as difficult as possible for this defendant to get her non-negotiable, which just also happened to be Dan Markel's non-negotiable, those two little boys. You have learned about this conspiracy and how it has unraveled over the last 11 years since Dan Markel's death. The defendants in this case have all attempted to point fingers at each other. They have argued that the state's theory is right. It's right. You got it right with everybody except for me. I didn't do it. The defendant sends Wendy this email, and it contains every date, like the date ranges that Dan Markel has been out of town traveling for work since the birth of their first child. That's 4 years. She is able to go back and send to Wendy, he was out of town this date to this date, this date to this date.
Because she had it all in her planner.
It's
I mean, I'm a
shocking
planner
that
girl.
She recorded that information, but we know she is a very detailed person. She keeps these extremely detailed day planners. But Dan Markel's travel schedule is of particular interest. In fact, in light of the fact that the hitman knew that Dan Markel had to be killed on July 18th because he was going out of town the next day. When the bump happens, you get to observe this defendant and her son in action working the problem. Neither of them would ever just lay down and let themselves get victimized by anyone. The bump is an actual recorded example of how these two act when they're threatened by an extortionist, in this case a blackmailer, and it's the complete opposite of how they say they've been acting before in the previous extortion. Several other things to note about this. Let's just compare like the two extortions, the prior one and the one with the bump. So when the bump happens, they resist, right? They don't open their safe up. It's only $5,000 compared to thousands and thousands of dollars they've been paying. $5,000, they don't pay. They resist. They take action. There are in-person meetings between Charlie Adelson and his mother, Charlie Adelson and Catherine Magvanowa, and eventually with Dad too, about the bump and what to do about it. The defendant eventually downloads a recording app and records a call to the would-be blackmailer.
She's highlighting that
So she records this call.
Charlie's tale of extortion, they all go, oh no, and pay it. But in this one, they have in-person meetings, they get face-to-face, they do all of this, and they don't pay. They're trying to figure out what happens if they don't pay. It's a good juxtaposition. So let's talk about closings real quick. We saw the prosecution touch on the things we thought they were going to talk about. I was not expecting the Spider-Mans pointing at each other meme. I was not prepared for that at all. I'm here for it. I was not prepared. We saw the prosecutor talk about what Charlie's defense was because it's an adoptive admission to Donna Adelson through her text. The truth is out. And because it lines up with the script. And even if the jury is like, jailhouse informants are just going to say whatever to benefit them, how do you explain the script? How do you explain what Donna wrote? And how do you explain that she's saying extort underline after she was Googling blackmail versus extortion? And how do you explain then that Donna was telling those in custody that she needed them to come in and testify for her? The prosecution says that was Donna trying to buy some favorable testimony. Did Donna bring in people to give her favorable testimony? Did we see that play out in this trial? And is that to be expected? Some of Donna's friends were really clear-cut, really straightforward. Some of Donna's friends were like, our Donna would never. And I mean, that's what one would expect from friends. It's not so much that her friend came in and was like, Donna would never. It's that it lends too, that Donna would do the exact same thing with those she befriended in custody, doesn't it? And that's what the prosecution pointed out. A really good point that the prosecution made that I hadn't really thought about much, because this trial, by the time we got to the end of it, I was like, is the difference of behavior between the bump operation. And for some of you just checking into this trial, because closing arguments are the best, the bump operation was an undercover operation to, as they say, tickle the wires and try to see what would shake out. What happens if we go and bump into Donna and like, hey, we know about the thing that the guys did up north. We know you're taking care of Katie, paying her. We need you to take care of our family. You need to take care of us. What do? How do they behave after that? And I think that, especially as to Charlie, they acted predictably. And then how did they act when they say that Catherine McBanawa was extorting them? Are those two behaviors the same? And I think the prosecution did a good job of highlighting the difference between the bump and between the 2 years running up to it. Because Charlie said, oh, they just went and committed a murder and then they came to us and were like, give us money. Or what? Or you're going to go to the police and say we had involvement in something we didn't have involvement in? No, we weren't involved. And now we know you were involved. We're going to go to the police and tell them that you're involved because you're trying to extort us for being involved when we're not involved. That's not what happened. The musty money was given to Katie. And Charlie told Katie, my mom washed it literally with water, not laundered it, washed it literally with water. So what is the jury going to believe? I was surprised the prosecution did not spend more time focusing on first-degree murder. The prosecution just said this is a first-degree murder, but didn't spend a lot of time focusing on the principal instruction and reminded the jurors that they talked about it during jury selection. So we'll have to see. I think the defense is going to focus a lot on that first-degree murder and the instruction to the first-degree murder and try to pull the first-degree murder out of this and say, look, if you can't get to there, you can't get to here, even with all these conversations. I think the conspiracy charge is going to be real hard for the defense. And I think they're going to go after the first-degree murder and try to raise doubt there as much as they can.
And I'd like to take you back to my opening statement. In my opening statement, there were some things referred to today that I'd like to address. The first one is that I stood up in my opening statement and said all of these wonderful things about Dan Markel.
She did.
And then I called witnesses to attack him. That is not true. That is not true. In fact, the defense is the only part of this case that actually elicited evidence through testimony about the good qualities of Dan Markel.
I would object to that.
We elicited that on cross from his ex-wife, Wendy. And all of the things I told you in opening about what a wonderful man he was, a wonderful father, well-educated, successful, we elicited that testimony. And criticized today for having two witnesses who came and testified on the stand about the dissolution case and things that had been filed in it. That was not to attack Danny Markel. We didn't put that evidence on. The state is the one that made it an issue. They put those documents into evidence, the things that Mr. Markel had filed. So we're the defense, and we represent Donna Adelson, and we're just supposed to say, okay, well, they've put it in, let's just let it sit there. We have an obligation to represent our client, and what happened in that divorce, whether it was contentious or not, was an issue the state brought up. They've been calling this a bitter custody battle for years. And they started this case by saying the same thing. So to have the people who were actually involved in the case point out that there never was a bitter custody battle is important, because there never was one. There was never a time when they were fighting over somebody having access to the children. In those pleadings, nobody says, you can't have them, I've got them. You can't have them, I've got them. When they filed their initial pleadings, they did what everybody, according to the lawyer who was on the case for Mrs. Adelson, meaning Wendy, on the case for Wendy, they all filed their typical pleadings. And in the beginning, you ask for certain stuff, and she asked for 5149, maybe for a tax purpose. But there was never one single time, and you can't be convinced that relocation was the issue where they were going to take Danny Markel's kids away from them. If you believe that, you are ignoring the evidence that the state of Florida put on against Donna Adelson.
Ma'am, did they take Dan's
And when I
kids away
told
from
you
him?
in opening that this was all about theory and belief of what a motive was, and there was no evidence that a crime was committed by my client, Donna Adelson, that is exactly what has happened in this courtroom. The state is ignoring the evidence that came in through their witnesses that support our defense, and instead they stand before you with calls and text messages and they tell you what they mean. That's not evidence. Their argument about what a conversation means is not evidence.
That's true.
You decide what it means. You've got it in front of you, and you have to consider it in the context of all of the evidence that's presented. Not just what the state puts in, but what the defense puts in. And I know at some point when we were putting on evidence, you all were looking probably at me like, what are you doing? Who cares? Some of those little things matter, and I'm going to cover those in the defense, and you'll see why we...
Hey, counsel, where was this level of self-awareness yesterday? Also, why are you yelling at them?
Sigfredo Garcia gets out and shoots him twice in the head, and they pull off at a pretty high rate of speed and leave Danny Markel dying inside his garage. Left him to die.
I mean, yeah.
Those are the people that killed Danny Markel.
Right.
Those two people. And
Donna
the state has all kinds of arguments about how Mrs. Adelson's involved because she said these things about him, and we'll get to that in a second. But if Luis Rivera is telling the truth, what did he tell you when he got on the stand? What did he tell you? He said, and this is his signature on this document dated March 11th, 2025, when he was deposed, and those numbers and circles are his. And he testified to you that... Where's my numbers?
Wendy
Catherine
wanted it.
Magbanawa, that's right. Catherine Magbanawa is the person that elicited Sigfredo Garcia to kill Danny Markel. Now her versions change over time, so we'll have to address a few of those. And then she says she didn't even know Luis Rivera was involved. This is a woman who the state has admitted lied first time, second time, third time, fourth time, maybe the fifth time. Every time she puts herself under oath and swears to tell the truth, she's going to say more. She told you she didn't even know Luis Rivera was involved, but the phone records that were put in by the state of Florida prove otherwise. Because during the time that they're traveling to Tallahassee, when she can't reach Sigfredo Garcia, whose phone is she calling? She's calling Luis Rivera. This woman can't tell the truth. Do you want to know what it accuses her of? That a 3- and 4-year-old said that they called Abba, that she had called Abba stupid.
Are we going to get at what she would have said?
And that drove her over the edge? One, she didn't know about it, but two, somebody claiming you said the word stupid, that's what brings us to murder charges? It's unbelievable. But that's their spin that they want to put on it, because they've got this theory that she's the mastermind. And then they stand up here in their closing and they say, everybody who's been charged in this case, so they want to point at the other one, and point at the other one, and point at the other one.
Well, they
No. Who is pointing at these people? The state of Florida. The state of Florida is doing the pointing. They're the ones getting the warrants. They're the ones doing the investigation. They're the ones charging people, deciding who they're going to give deals to and not. That's them pointing the finger. That's not my client. There's no evidence of that. They bring the charges, they prosecute, they get the convictions, they get people sent off to prison. Not us.
I mean, they did do that.
What? We're pointing the blame at the killers for killing them? They proved that those are the people who killed them. That's not us pointing the finger. They actually did it, and it's been proven. And we're distancing ourselves from Charlie Adelson? Let me tell you something.
Tell me.
They elicited the testimony about Charlie Adelson over our objection, if you happen to remember that. It came in. Charlie Adelson is not on trial
Anymore.
You may be sitting in that jury room thinking, well, Charlie did it, and it sure looks like Wendy did it. That doesn't have an ounce to do with Donna Adelson doing a thing. Not a single thing. If you think he did it, he's been convicted. He admitted in his testimony that he is the person, although he claims he was extorted, he is the person that took $138,000 out of his refrigerator-size safe that he has at his house with the money exactly like he says he kept it, stapling $100 bills together in stacks of 1,000, staple, 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 staple.
Damp dollars?
He said he took that money out of his safe and he gave it to Catherine Magbanawa that night. Whether that's his girlfriend and they're still fooling around on the side, that's between the two of them. That's got nothing to do with my client.
I mean, she kept putting herself into the middle all
He
that.
did it. But now they want to say Donna Adelson did it. Pick one. You don't like our theory? That's what they say. You don't like our theory? Oh, well, you like our theory on everybody else. Pick one. If you have prosecuted Charlie Adelson for paying the $138,000 stapled just like their other witnesses in this case said, why are they now saying Donna Adelson provided the money? Oh, wait. Oh, because Catherine Magbanawa, who's been sentenced to life and is telling her sixth story now, has decided she'd like to see her kid someday.
Oh, there's
so
the
now
life.
she's going to come in and provide information that will help the state prosecute an innocent woman so she can go home to her children. That's what that's about. And just like I said in opening, what the state thinks happened does not matter. What they believe happened does not matter. What spin they want to put on it does not matter. You can only make your decision based on the evidence presented to you, and up through the time that Dan Markel was killed, that's all they got. She said some ugly things, and she meddles in her children's lives. Meddles in their lives. Gets involved in their divorce. She's a parent. She's just being a parent, not a killer. She's a meddler, not a murderer. They haven't proven that to you. Murder in the first degree.
Oh, good.
The state has to prove that on July the 18th of 2014, Donna Adelson intended that Dan Markel be killed on that date. They have to prove that. There's no evidence of it. First-degree murder is killing with premeditation. Is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The premeditated intent to kill must be formed before the killing. They've got no evidence of her doing anything until after Mr. Markel is dead, when she writes the checks at the instruction of her son. Conspiracy. The state has to prove beyond a
I think
reasonable
that's their
doubt
strongest argument.
that the intent of Donna Adelson was that the offense of first-degree murder would be committed on the date that he's killed, not after the date, before and up to the time that he shot and killed. They have to prove beyond a reasonable doubt that she had that intent, and they have nothing. Solicitation to commit first-degree murder. They have to prove the following two elements beyond a reasonable doubt. I'm sorry, back to conspiracy. I forgot to say this.
Okay.
In order to carry out the intent, Donna Adelson had to agree, conspire, combine, or confederate with Charles Adelson or Catherine Magbanawa or other persons to cause the first-degree murder to be committed. Had to be before. No evidence of it. Solicitation. Prove the following two elements beyond a reasonable doubt.
And moving on to
Donna
solicitation.
Adelson solicited Charles Adelson or Catherine Magbanawa or other
others.
persons to commit first-degree murder. During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine Magbanawa or other persons to engage in specific conduct which would constitute the commission of first-degree murder. What does solicit mean? It means to ask earnestly or to try to induce another person to engage in specific conduct. We know that the state has not presented evidence of Mrs. Adelson actually shooting and killing Dan Markel. They are asking that you find her to be a principal, that these other people did the killing, but she's a principal. And to prove that she's a principal, you have to show that she helped another person or persons commit the crime. In doing so, the state has to prove beyond a reasonable doubt that the defendant intended the crime to occur and the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. For first-degree.
So that's the instruction on principles. This goes to count 1 and count 3. Counsel is going through the jury instructions, which I think is absolutely critical for the defense to do in this. So she is going through what a principal to the first degree and solicitation mean.
There is no direct evidence linking Donna to anything. And all this circumstantial evidence isn't really circumstantial evidence. It's argument about what it could mean, what it possibly mean. Could it have been? That's not beyond a reasonable doubt. Thank you.
We will continue to debate whether the defense addressed the script or didn't address the script. She talked about the writing. She kind of argued it, but she didn't say script. She kind of sidestepped it. The defense brought up some connections and some points that might help if there are jurors that are like, hey, yeah, I'm real curious about that. Made some connections where I'm like, that's a good point. But she yelled at the jury for quite a long time in a way that I don't know if it will be helpful to the defense. But there were points where she said, look, the defense wants this inference, but what about this inference, which leads to doubt. I appreciate that the defense did go through the jury instructions and say this jury instruction and that jury instruction, but I worry that because she was yelling and just banging the lectern for the first half of her closing, that those points will be lost. And the end of her closing was, this happened in 2014. If they had any evidence, why are we here now? Why didn't they do this sooner? Why did it take them 2 years? Why are they still investigating? And at the end, she said to the jury, you know, don't buy into the state getting up here telling me I'm wrong. The only thing you can do is go back and find the defendant not guilty.
This murder charge is not based on the fact that she said some bad words. I mean, I'd be facing murder just in this courtroom. Obviously, people. That is not what this case is about. You've got to look at all the evidence. I mean, it is death by 1,000 cuts. It is powdered sugar. You've got to look at the whole thing and make a decision. And I'm sorry that there's not a smoking gun, but she was too smart for that. She thought about it. She planned it. She made sure we could never get her, right? She took precautions, but she did make mistakes. And that's what all those exhibits are. Mistakes. My spin and the spin I'm putting on all the evidence, that's not, it doesn't matter what my spin is. It's your spin. You look at the evidence, you decide. I tell you what I think it shows. They tell you what they think it shows. What's the other side? What do they think it shows? They don't have to prove anything. I have to prove the case. Yes. But what are they saying? Charlie, definitely. Wendy, maybe. Not Donna. But also, not Charlie. We were getting extorted. Not Charlie. I mean, you can't have it both ways, right? It's like hard to get your head around it, but we can't be getting extorted by the killers who killed Dan Markel on their own. And also, Charlie's pretty guilty and Wendy looks a little guilty too. It's got it like, there's no lane that's been picked. And they don't have to prove anything, but they're throwing all that out, right? And it's like, you were getting extorted, or Charlie and Wendy did it behind your back and they don't tell mom what they're doing. 2 years after the murder, we've got 2 emails, 64T and 64I. The defense told you in opening that this defendant cares about others more than she cares about herself. The problem is that she decides what other people need, what's necessary for other people in their lives, and she is willing to justify whatever ends she thinks are needed, right? Any means to get to those ends are justified in her mind. The problem is she doesn't care about the collateral damage to get to her ends. The evidence has shown that this defendant, I think, did believe that Wendy and those boys were better off in South Florida. She thought that's what they needed. They would be better off with her. And she was angry that that couldn't happen. Dan Markel is the thing standing in the way. What was the cost of that to not only Dan Markel, but to those little boys? Those little boys lost their father. Look what she says in 64T. Children are 2 and 3. Children do not even have a memory of life before age 5 or 6. Look what she says in 64II when Wendy is concerned. This is 2 years after the murder. Her child is having trouble at school, crying because he misses his father. And this woman, this nice grandmother, innocent woman says, quote, "I still do not believe that Ben is sad about his father." Quotations on the sad. 64, I still do not believe that Ben is sad about his father. I spend a minimum of 25 hours a week with him, and oftentimes more than that, including weekend times and sleepover days, and have never experienced a time when he was sad. I think it's just another phase of the many, many phases that kids go through. The problem is they have a highly intelligent and sensitive mom. She doesn't believe that this kid is sad because she can't take accountability for her own actions and the catastrophic consequences that this had on everyone's life in her family. Not just her son, not just her daughter, not just Rob, not just Dan Markel, but those boys who lost their father. It wasn't better for them to be in South Florida. It was better for them to have their father. You must not base your verdict on the feelings of sympathy, prejudice, bias. Your verdict must be based on the evidence and the law. Yes, she's a grandmother. Most murderers don't look like that. But the evidence has revealed what she is. Please don't let her appearance influence your verdict in any way. It involves the two of us. What about the script? They didn't even talk about the script. She wrote a script for a witness that was perjured testimony based on a lie, an extortion lie that's been proven in court to you to be false. This defendant tried to erase Dan Markel, thinking there would be no harm to those little boys. They don't have a memory of their father. They feel the absence of their father. This defendant decided they didn't need their dad. She doesn't get to decide that. She wanted it done. She brought the money. She stroked the check. She didn't have to do that. Charlie was a signatory, had signing power on that account. He could have written the checks. She wrote the checks. Why? Because she was neck deep in this thing. She wrote the checks. She said it involved the two of us. She wrote that script. May you have the strength and the common sense to see this evidence for what it is. It's only one thing. There's only one truth. It can't all be right. It's only one truth. Render a verdict that does justice. Find her guilty.
That's the end of the prosecution's rebuttal. The court is going to read the final instructions and the jury will be sent out to deliberate. The rebuttal was fast. You could tell that time was getting to this prosecutor, but you can also tell she wants to make sure that the jury gets it because it is so much. And she was trying to say, it's this and it's this and it's this. It is the puzzle pieces and it's a lot of them. And the jury has to put that together. And so at the end, she said, look, there was only one truth. It can't be all of it. Do justice in this case, find her guilty. The prosecution was running up against time hurdles. It's been a very long day. It was a very quick trial. And you could tell that the prosecutor wants to make sure that the jury gets it. You can tell from the defense that the defense was saying, look, nothing points to my client. And I think the prosecutor really wanted to make sure that the jury knew what all those puzzle pieces were. The jury is out deliberating. That was a very full day of closing arguments. We saw some of the arguments from counsel that we thought we would see, and some arguments that surprised me. Some connections that the attorneys made that I hadn't thought about, but I'm not surprised. The attorneys have been with this information longer than we have, especially when it comes to the prosecution. Time was a little bit of a factor for the prosecution. It didn't feel like the defense felt rushed in their closing. I felt like the defense was taking their time in their closing, where at the end, the prosecution was like, and then there's this, and then there's this, and then there's this. And it felt like they were zooming. In Florida, the courts often let the jurors continue to deliberate if they want to, but if you are feeling kind of drained and tired from today and like the whirlwind of the last couple days, I imagine that the jury is too. This is a case that has lasted, with jury instruction, 3 weeks. I wouldn't be surprised if the jury took the night to think about it, especially considering that they are getting this case at the end of the day. I wouldn't read anything to that or into that. I wouldn't say, well, if they take the day, it's because they're doing this or doing that. Given the late hour, it would actually surprise me more if they didn't take time to sleep on it and then come back in the morning, but we'll see. They might be like, done, let's go. But at the end of day 9 of trial, the jury is deliberating. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.